All right, good morning. Or is it good afternoon, rather. It has been reported that a quorum does exist for the Special Select Committee to commence business. Those in favor? Yeah.
Aye.
Good. Quickly, can we look at the agenda for today? Do we have any amendment, or should we adopt it as it is?
Yes. On number 3, I think we should move it to the end.
Okay, number 3.
Yeah. Right after number 7.
Okay.
Yeah.
All right.
So with that, I move that the agenda be adopted amended.
Thank you. It has been moved and seconded that we adopt the agenda with amendments. Good afternoon, Mr. Prom again. On behalf of the Special Select Committee of the National Assembly, I welcome you to this sitting committee to inquire into the sales and disposal of assets identified by the Commission of Inquiry into the financial activities of public bodies, enterprises, and offices in relation to their dealings with the former President E.J.J. Jammeh and connected matters. You are appearing today in response to a summons duly issued by this committee to provide testimony on matters within your knowledge and are relevant to the subject of our inquiry. Please be reminded that you are appearing under oath and pursuant to the provisions of the 1997 Constitution of the Republic of the Gambia. It constitutes contempt of the National Assembly to knowingly withhold, misrepresent, or conceal any information relevant to the committee's work. You are also advised, in accordance with parliamentary privilege, any statement or testimony you provide before this committee shall not be used against you in any court of law, except in cases of perjury, where it is proven that you knowingly and deliberately provided false information while under oath. You are therefore expected to cooperate fully and provide truthful, accurate, and complete responses to all our questions posed to you, whether by the committee's legal counsel or honorable members of this committee. The committee appreciates your presence and expects your utmost candor and cooperation throughout the proceedings. Secretary, can we administer the oath before we allow the witness to say anything?
Thank you. I, Louis Prom, advisory partner of Augustus Prom Audit Tax Advisory, do solemnly, sincerely, and truly affirm that the evidence I shall give before this committee shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you, Mr. Prom. Quickly, before I hand it over to counsel, can we do a quick introduction? That's also important. I am Honorable Abdullah Sise, Chairperson of the Special Select Committee.
Honorable Mali Sise, Vice Chair. Honorable Sripsar, Member. Omar Jame, Member. Honorable Sohaibou Touré, Member. Honorable Kewalam Fufana, Member.
Honorable Alhaji Mbow, member.
Good morning. My name is Ajisi Nika, and with me on my left is Mr. Lamin M. Diba, and on my right is Mr. Tony F. Mendy.
Thank you. We also have our secretariat and other staffs in present. Thank you, Mr. Prom. So we'll take you through the testimony. Back to you, counsel.
All right. Thank you very much, Honorable Chair. Mr. Prom, can you kindly state your full name and current designation for the record?
Yes, my name is Louis Prom. I'm currently the advisory partner of Augustus Prom Audit Tax Advisory.
Okay, thank you. So now what we're going to do is just confirmation. I am going to put things to you and you just confirm. Can you kindly confirm whether you received a summons to produce documents for this honorable committee?
Yes, we've received 2 produce and we've responded to them.
Very well. You were also sent a summons to give a statement to the panel of investigators.
Yes, that has been completed. and submitted.
And you gave a statement?
Yes.
All right, thank you. Honorable Chair, I believe the committee has a copy of Mr. From's statement, and we can mark that as AP1A.
AP1A.
Yes. Thank you. And Mr. From, finally, you received a summons to come and testify here today.
Yes, we did.
All right. So, Honorable Chair, the witness has submitted documents to this committee, and it's, I can say, on a rolling basis. Yes, we've sent him 2 summons to produce, and he did submit documents, and last week as well, he submitted some documents via email as well. They are yet to be marked accordingly. However, I believe the committee has a copy of all the documents he has submitted, and I'm going to propose that we just adopt them as a bulk, yes, and then we can just get into his testimony. It's quite a lot, so if you want to do that one by one, and they were not, unfortunately, we did not pre-mark them, so it's going to be a little bit tedious. But if in any event, if I'm referring to these documents, I'll just direct the committee to which one I'll be referring to. Thank you. All right, Mr. Prom, so we can now start your testimony. So kindly give the committee a brief overview of what Augustus Prom and Partners does, and just a brief history as well about the company.
Yes, the firm was established in 1984, over 40 years ago by my father. Core services, audit, tax, advisory, payroll, M&A. So over the years, we've been diversifying our services. In terms of client base, we have Gambia government, a lot of parastatals. We also have international NGOs, local NGOs, multinational companies, local companies. We also audit and do consultancy for projects funded by the World Bank, EU, ADB, ISDB, Japanese grant, basically all the donors, we engage them. So we are one of the oldest and largest accountancy and consultancy firms in the Gambia. We also offer insolvency services, which covers this receivership and liquidation. Even, Gambia being a small economy, you don't have much activity in insolvency and M&A, but it does come up time to time. And this one we're on, it was an exceptional one as we go through the testimony. So I'm overseeing the advisory unit. It covers tax, M&A, payroll, also insolvency as well. I have about almost 20 years of industry experience. When I came home in 2007, my first engagement was a receivership for GAMCO, Gambia Agricultural Marketing Company, which there was a dispute between Social Security, the investor, and some Nigerian investors. So the firm was hired to be a receivership for about a year. We were managing the groundnut factories and took custody of the assets. So we've been providing insolvency services since the 90s, and also we do insolvency for private companies, what we call the voluntary winding up through the Companies Act. For example, for multinationals that want to exit Gambia, unfortunately a lot of them have been leaving, such as BP, Standard Bank, but we didn't do their wind up, we did the one for BP. So insolvency services is one of the aspects we cover as well, but it's not very frequent because of the size of the economy.
All right, thank you for that. Let's move further into your testimony. So the next couple of statements I'm putting to you, and you confirm, and we can get further. Are you aware that in 2017, the government of the Gambia established a commission of inquiry to look into the assets of the former president and that of his close associates as well, to investigate financial dealings of the former president?
Yes, I'm aware.
Yes, and you are aware that before the establishment of the commission, the government made some efforts to preserve these said assets of the former president and his close associates?
Yes, via High Court orders.
Yes, very well. So let's take a look at MOJ 5A, Honorable Chair. MOJ 5A is the order to help the witness. It is the order of the High Court issued on the 22nd day of May 2017. This is part of your submissions, but in your submissions, the annexure is missing. All right. So let's talk about MOJ 5A. In this order, you take a look at paragraph 8. The firm, the Augustus firm, is hereby appointed by the court. If you can just read out paragraph 8 for the committee, please.
Okay. Paragraph 8, High Court order dated 22nd May 2017, that it states that Augustus from a firm of certified chartered accountants registered in the Gambia be and hereby appointed receiver and consequently the custody and control, and is hereby granted to them of all companies listed in Annexure 3 attached to this order for a proper administration thereof pending the conclusion of the investigation by the Attorney General. And it also states that it is ordered pursuant to Section 51(5)(a) of the Act that the power granted under paragraph 8 above to Augustus from a firm of chartered accountants registered in the Gambia shall include the power in the case of perishable or rapidly depreciating property to sell that property, including stocks and bonds.
Thank you very much. Now, before we talk about what happened before the order, sorry, what happened after the order was issued, delivered by the High Court, let's talk about the incidents leading to the Attorney General filing a suit against the former president and subsequently seeking for custodial and freezing orders from the High Court, which here is the order of 22nd May 2017. Prior to the order being delivered by the High Court, did you, or did, by you here I'm referring to Augustus from the firm, was the firm contacted by the Attorney General's chambers at any point before 22nd of May to discuss issues of the firm being appointed as receiver of some of the assets of the former president?
Yes, we had a phone call from one of the state councils, Kim Bengta, and he gave us an overview of the engagement. By that time, Ministry of Justice already has a profile in terms of the services we offer and requested if we'll be interested. So we told him we'll get back to him. We sat, looked at the, I guess, risk, cost, benefit, taking into account it was supposed to be for 6 months and our profile and capacity. We told them, yes, we'll engage. And then after we had a meeting at Ministry of Justice to discuss on the engagement and fees. And then subsequently, there was a letter from Ministry of Justice, which we submitted.
Can you remember the date of the phone call from Mr. Ta?
No, I'll have to make reference to file.
Okay.
But it was before the court order.
Okay, please do. Yeah. What about the meeting with the Attorney General at the Attorney General's chambers? Was this also before the order?
Yes, it was before the court order.
Okay.
We had notepads. I will not say minutes, but I guess you can call it minutes. We had field notepads where we were jotting the dates, but we didn't scan all of it, so we're looking for it. But it was before the court order.
Okay, so when you say we, who are you referring to here?
Basically the firm, myself,
okay.
My father, managing partner, the other partners as well. Okay. It's a family business.
All right.
So,
who else was present at this meeting apart from members of the firm?
I was there. The managing partner was there.
I mean, apart from the staff of Augustus Prom, you said the meeting took place at the Attorney General's chambers.
Yes, in the conference room.
Yes, was the Attorney General with other officials or was he alone?
No, the Attorney General was not there. It was the former SG, Cherno Morena.
Okay.
He chaired the meeting. We were there. There was also senior police officers not the IGP, but they were senior based on their uniforms, white and medals. I believe Registrar General was there as well. So Binga, former Director of Litigation, was there. So it was like a task force. And there was, the former SG, Marina, was chairing the meeting.
Okay.
You want me to go into detail or?
Yes, but you mentioned Registrar General. Can you please state the name of the Registrar General at the time?
Aliu Jallo.
All right, thank you very much. So can you just inform the committee what was discussed at this meeting?
Well, it was not a long meeting, about 30 minutes, but I remember hearing the word, we have to move fast, because taking into account at that time the political context of Gambia. The former president had left, he had a lot of valuable assets worth billions, and people were stealing, people were claiming. So I think the government's objective or intent at that point was to secure assets, companies, bank accounts. So I remember the word, you have to move fast, and which we did in terms of visiting locations, writing to the banks, and freezing assets. So, but it was basically just an overview of what each party had to do. Police provide security, Registrar General visit the locations, and Augustus Prom secure the companies. So.
All right, and then subsequently, the Attorney General instituted a suit and obtained this order from the High Court.
Yes.
Okay, so was payment of fees for the firm discussed at this meeting, or was this discussed after the order?
No, it was not discussed at this meeting. There was another meeting. To be honest, I can't recall the dates, but it was around the time the order came. So what we did, we submitted what you call a receivership fee proposal. We haven't sent it to you yet because I'm looking for a signed copy. All I have is the electronic copy. But we'll forward it to you by Friday, including other documents, because it's a large volume of records, and we have to extract, compile, segregate, otherwise we won't respond on time. So, but at some point, to be honest, I don't remember the dates, but we did send a fee proposal, and it was accepted by the AG, and it was revolving around the rate 10%, and 100,000 for the dormant companies for 6 months.
All right. This acceptance that the Attorney General did at the time, was it in writing or did he do this orally?
It was in writing. I think we got a copy.
Okay.
Yes.
So subsequently, the order was obtained from the High Court. As you can see on the order, it was obtained on the 22nd of May, 2017. So after that, when did Augustus Prom receive information that now the order has been obtained? Did the Attorney General ensure a copy of the order was served on AP, or how did you receive information about the order?
It was sent to us with a cover letter. I believe the Sheriff Division also wrote, but it was more to the other parties in terms of their cooperation that Augustus Prom is the receiver. So there were two letters, one from the Sheriff Division, one from AG. But the AG's cover letter came after the High Court date.
Yes.
So,
okay.
But at that time they were overwhelmed, so it wasn't a surprise. But they did write and giving us, it was submitted to us before during the meetings, and then they sent it again with a cover letter to, I guess, officialize it.
Honorable Chair, if the committee can take a look at the last binding of documents submitted by the witness. This was, I believe, supplied to the committee on Friday. It's a letter dated 1st of June on the letterhead of the Attorney General's Chambers. It's dated 1st June 2017. And the subject matter of the letter is the Attorney General versus Yahya AJJ Janneh, notification of appointment as receiver. That is the letter that the...
Sorry, Counsel.
Yes, you don't have a copy of that.
Yeah, could I see the copy?
Yes, please. Secretariat, I'll give you my copy.
Council? As a rule? Council, can we proceed? Yes, while we work on it.
Yes, please. So I just wanted the committee to take a look at that letter. So, Mr. Prom, the order was delivered 22nd of June, May, and then you got that letter on the 1st of June. Did you respond to this letter?
Yes, I'll have to make reference to file, but there were many correspondences. I think we responded and also mentioned the fees, and then they responded on the rates to go by.
All right, very well. Before we get into the activities that took place after the order, you mentioned that the sheriff wrote a letter informing, was it informing you or was it informing the employees of these companies that were now placed in your custody and control about the receivership?
We'll send you a copy this week. I'm not sure if it was part of the documents we sent, but it wasn't addressed to us. I think it was an open letter, and it was requesting for, just giving notification that we were a receiver and requesting for cooperation. But we were mentioned in the letter. In terms of who it was addressed to, I believe it was an open letter, because we were dealing with many companies at the time.
Okay. Honorable Chair, the letter he's referring to has been submitted by the Honorable Justice TABALLY, and it's marked, I believe, SBT 7, if I'm not wrong. Let me just confirm. Yes, but it's part of the submissions of the former sheriff. At any point in time after this order was delivered by the High Court, did any official from the firm visit the office of the sheriff requesting for either support or preparation of notification, a letter of notification for the companies that are now placed under the firm's custody and control?
No, I think the sheriff was part of the task force. But in the beginning, we were moving with the sheriff, staff, and Ministry of Justice staff, police officers. So once the order was out, we had to move fast. We were moving as a task force. But I don't recall going or the firm contacting the sheriff's division. Our main contact was the Ministry of Justice. But we did receive a letter from the sheriff division, but we never engaged them. But they were part of the task force we were with in the initial stages of the engagement in terms of going to different locations.
Okay. The sheriff at the time in 2017 testified last week and mentioned that this letter that you are mentioning that was addressed not to you but to other individuals, he testified and gave evidence that the letter was prepared at the request of Augustus Prom, and that the letter was to notify these companies, the employees, the management of these companies, that these companies are now placed on receivership and it is Augustus Prom that is the receiver. So now that you're saying you never visited the office of the sheriff, but just met with them at the task force, what do you have to say to this?
Well, I cannot recall a letter going to the sheriff, but it's, there were many correspondences.
Sorry, it did not say a letter. It said it was done in person.
Well,
it was a visit.
This was 6 years ago. I don't recall engaging the sheriff, but I know he was part of the task force. So it's possible it was requested. But, taking into account it was 6 years ago, I don't remember all the engagements and conversations, but it's possible, since he was part of the task force, maybe my father requested that he should write. But I personally, to be honest, do not recall that request.
Visiting the sheriff and asking for that letter?
I don't recall visiting the sheriff's office. I don't, to be honest. Since I'm on the oath, what I recall, I'll tell you. I have no reason to hide or be afraid. But I know that the sheriff's division was part of the task force in the beginning. Maybe it's possible it was requested, but from my own memory, I don't recall it. Maybe it was requested to reinforce, but I personally cannot recall going to the sheriff's office. I know we were visiting Ministry of Justice for meetings, but not the sheriff. I can't recall the sheriff.
Very well. Now that you've mentioned the task force, I think we can go there. Did the firm receive an invitation to join the task force? A written invitation?
Not that I recall. It was discussed during the initial meeting, and also taking into account there was coordination, phone calls, so there's a possibility it was maybe not put in request. But I do remember the first meeting, it was a task force, different organizations and divisions and police. But it's possible. But there were also a lot of phone calls as well. You cannot put everything in writing, especially if you have to move fast. A lot of meetings. So I don't recall any particular letter requesting that. But I know that there was a coordination effort, and we were moving with the task force. That I recall.
All right. So you received an invitation to, either by phone call, maybe, let's say phone call, to have a meeting with the task force at the Ministry of Justice. Who represented the firm at this meeting?
I was there, my father was there.
Okay. Do you remember who else, other officials from the government that were there? You've mentioned the sheriff was present at the meeting, so can you inform the committee which other officials were there?
Well, I recall the meeting was chaired by the former Solicitor General, Marina. There were senior police officers. I can only recall one. I think it was Landing Bojang. He was head of PIU. He was there. And we did comment on security concerns. And the police said they will take care of that. I recall Director Civil Litigation, Binga was there. All the people that were present, I can't recall name for name, but I know that it was a task force. And you had police officers, Ministry of Justice, the receivership, and also the Registrar General.
Yeah, but the Registrar General was not the one chairing the meeting.
No, it was the former SG, Solicitor General, from what I recall. And I remember the word, we have to move fast. Assets are being stolen every day.
Thank you. Can you just tell the committee what was discussed, apart from we have to move fast? Assets are being stolen. What was discussed in this meeting?
Well, I recall, this was 6 years ago. And, I cannot testify something that I cannot properly recall. But I know it was mostly about the assets, that, there was concern that assets were being stolen or claimed. The former president was no longer on the ground. People were coming out of the woodworks claiming all sorts of things. So I think it was a prudent decision at that time for the government to secure the assets and put in certain measures in place, which was done. So at that point, I think it was the right decision by the government to put in place certain measures. But other security concerns were raised. I remember at some point, there was a slight frustration on the SG. I don't remember what caused it, but I remember there was a slight, little bit of frustration, but I don't remember what the trigger was, to be honest. So But I remember the words clearly, we have to move fast, assets have been taken.
All right, so after this meeting, you stated that you cannot remember the date, but after this meeting, what actions did the firm take to secure the companies and the assets of these companies that were placed under its custody and control? And you can take a look at the third annexure of MOJ 5A. There's a list of companies. Yes, it's the last page of the order.
You can keep the mic on. You can keep the mic open.
Sorry, it has 11 companies, but I think it was 14.
It's 14. All right, your copy has 11, but it's 14 companies. So can you just tell the committee after this coordination meeting,
yes,
what happened? Because you've mentioned that at some point you had to visit these companies, but with the task force. So you did not do this alone. You had security and you had. So from there, you can just explain visiting these companies and what else was the first steps that the firm took.
Yes, moving with the task force, we first visited, I believe, the Abattoir in Abuko. And we gave them a copy of the High Court order. We gave them a briefing, basically. And then after we visited KGI, we visited the KGI retail sites on Kairaba Avenue, I believe the bakery and the butcher shop. And then, so basically it was, the initial stage is what you call the due diligence stage, where you secure, collect information. We also notified the banks that there's a receiver in place. We also notified the company's registrar, as required by the Companies Act, that there's a receivership in place, and we were requesting documents on these companies. But as stated earlier, most of these companies were dormant, the majority, I think 90%. So, and some of them didn't have assets. But the main active ones were the Abattoir, KGI, and eventually BPI Tourism, the hotels in Bakau. But the majority were dormant. Some had no assets, no trading activity. So.
All right, but in these 14 companies, was BPI was not part of these 14 companies initially, was it?
No, you know, you had 17 companies on the High Court orders. Then
I don't want us to get into the other three just yet, because they came about a month or so later. So we will get to them.
Okay.
Just these 14. We can just stick to these 14.
Okay. Yes,
the visits and...
Yeah, BPI came later.
Yes, BPI came later, right?
Yes.
We will get to BPI.
Okay, no problem.
So, all right, when you visited these companies, you've stated that, and in your statement, that only three were active.
Yes.
Were active and functioning with staff and...
Sorry, two.
Sorry, only two.
Before BPI,
Before
yes.
BPI, only two of them, which was... you stated paragraph 3 of your statement. I believe you've been given a copy. It's before you.
No,
your statement is not before you?
I just have the High Court orders.
I'll just read the... Yes, it says KGI and KFF Abuko Abattoir. So these are the only two that you found active.
Yeah.
So before we get into the ones that you found active, let's talk about the ones that you found inactive.
Yes.
Did they have, did you have addresses? You visited these places and you found the offices were closed. Yeah. How did you go about ascertaining that they were inactive?
The information in terms of location came from the task force. How we were moving. We also visited Canalai Farms, the head office. It was behind State House near the market. But there was only a security guard. There was no activity. It was like a new office. So the information in terms of office location was coming from the task force, from what I recall. You know, and there were not many locations, apart from KGI Future Egg Building, KGI retail sites, and the Abattoir. Those, and also Africa Royal Holding on the Indum Highway. That was another office as well, but it was dormant. So, yes. So, but to be safe, there were 2 active companies. All the others were found. Then later also, I think Observer as well came on board, but that was after. I think it was the second court order.
Yes, Observer falls on the second. Let's just get into the second one. Honorable Chair, I'm referring the committee to MOJ 5C. If Secretariat can help the witness find MOJ 5C in that binding that he has. He's on 5A, so 5C should not be very far.
Yeah, thank you.
Are you there?
Yes, go ahead.
Honorable Chair, can I proceed? All right. So, Honorable Chair, the MOJ 5C is an order of the High Court delivered on the 21st day of July 2017. Mr. Prom, I will direct you to paragraph 4 of the said order. Paragraph 4 and paragraph 5.
Yes.
So paragraph 4 has appointed the firm, Augustus Prom, to be receiver for Westwood Gambia Limited. The second one is Maligam International, and the third company is Observer Gambia Limited. So now you have the 17 companies.
Yes.
We can talk about all the 17 companies. So to make it very organized, what I'm going to do is I'll give you a name of a company,
okay,
and then you just tell me when you visited or what you found in the beginning, right? So let's start with Africada Insurance Company. That should be in MOJ 5A.
Okay, no, go ahead. I call the companies. It's a bulky document. You can go ahead.
Yes, it is. So Africada Insurance Company, I'll give you the shareholders, Biran Nba 1%, and then Royal Africa Capital Holding owns 99%. What did you, when you commenced work, what did you find about that company? Was it part of the dormant companies?
Africada Insurance?
Yes. It's part of the 14 that the High Court placed in your custody.
Royal Africa had about 10 companies, subsidiaries.
Yes, so there's Royal Africa Capital Holding.
Yes,
Limited.
Africada, I can't remember having any activity, but there was a forex they had that was open, but it wasn't active. They had a forex shop, but it wasn't active. Africada Insurance, I can't recall coming to our office. You know, all their companies were based in this house that was converted to an office on the highway in Yundum. So, but when we went there, it was just guards. There was no like admin staff, or, you know, a company will have some level of activity. You'll know that clients are coming in, admin, you name it. But it was dormant. And they had like a forex shop, but when we went there, it was found closed as well, from what I recall.
So there was a forex bureau, but it was not operating as well.
Yeah, I believe they had a forex bureau in the list of companies. If you look at it, was, I think, airlines and all these things.
Yes.
I think.
So there's also Africada Airways, Africada Microfinance. Is that what you're calling the forex bureau?
Well, it could be. Is there another forex list there? But
yes, there's Africada Financial Services and Bureau de Change.
Yes, they had a forex shop, but when we went there, from what I recall, it was closed. So.
All right. So these offices that you visited and they were closed, were you able to get access to the building, yes, or the
yes,
grounds?
Yes, we had access.
Okay. Did you inspect and see if there were any assets in these buildings, or were they just empty buildings with no furniture?
No, Africa Royal had furniture. There was a Range Rover. we took inventory and we secured it. That's what we did for Africa Royal Holding. But there were documents as, you know, we do the due diligence, and the documents, it seems this group was at the initial stage of setting up in Gambia. You know, the former president's brother was a minority shareholder. So, but all indications are it wasn't launched. It was in the process of getting financing from abroad based on the due diligence we did. But I will not say it was an active group. It was at its infancy stage. So maybe they were anticipating some support from the former executive, and then politically things changed. But during the due diligence, we didn't see any. They had bank accounts as well, but there was not much there. I don't remember the exact amounts because there were so many bank accounts, unless you make reference.
All right, so when you got access to this building and you found a Range Rover, you found documents and stuff like that, you mentioned that you secured them. By securing them, what do you mean? Did you appoint security personnel to be stationed at this place, or what did you do?
Yes, some locations we had police guards, depending on what for former IGP could provide. So certain locations we used private security, but any location that had access, we had private guards. I believe the army was guarding the warehouse at the airport, so there was security.
All right, you've mentioned the warehouse at the airport. Which of the companies was managing the warehouse at the airport?
We found it dormant, but there were two warehouses. You know, the World Bank under the Gypsum project built warehouses at the industrial park at the airport. So these two warehouses were taken over by Westwood Limited, the timber company, and MCG, Mineral Company Gambia Limited, which was a gold dust refinery company. But they had valuable equipment in the warehouse, so because of the equipment, we just secured it. We took no steps to bring it into operation. So, and we were operating on 6 months mandate. So, but there were two warehouses at the airport, and it had valuable equipment, from what we recall. And we took pictures as well, and inventory as well, which I think we've sent the inventory reports.
So, is it that the firm decided not to ensure these companies were operating because of the duration of the receivership, or the initial duration of the receivership, or was it that the firm had just made decision to secure and just hold custody until the government tells the firm what to do? Because if you take a look at paragraph 9 of MOJ 5A, it states that, I don't want to read the entire paragraph,
Yeah.
but it states that the powers of the firm shall include the power in the case of perishable or rapidly depreciating property to sell that property, including stocks and bonds. So for these companies that were dormant, didn't the firm ever think then maybe we should sell the assets that these companies have, or maybe the stocks and bonds? What did the firm decide to do with these dormant companies?
You know, initially, you're looking at a 6-month order, so that does not give you much time in terms of corporate strategy or planning. So basically, the strategy was, if it's active or going concern, we position a deputy receiver manager to enhance oversight and controls, and we try to stabilize and maximize profit. If it's dormant, we secure and take inventory. This was, you know, we didn't expect it would go for 6 years. Stocks and bonds, we had the legal authority to sell. KGI had about $5 million in stocks. We didn't sell it. It was transferred when we handed over. We had authority, we didn't do that. So as far as sales was, you know, our mandate was focused on management, not sales. You know, and you know, you're talking about sovereign assets, dangerous assets. So we were very careful as well, not to do something that tomorrow could backfire on us. So our position was also, we give everybody an ear, but we were very defensive, and it led us to having some enemies, I guess. So, but no, we didn't sell stocks and bonds, and the focus was management, not on sales. But if the company was active, we'll continue your business objectives and try to stabilize and enhance profit, which we did.
All right, very well. So let's go back to the warehouses at the airport. Yes, the initial period for the receivership was 6 months,
Yes.
180 days, but the Attorney General kept going before the expiry or at the end of the 180 days, would go back to the High Court and renew, and
Yes.
this kept going on from May 2017 to June 2019.
Yes, 2 years.
So 2 years.
Yes.
Did the firm ever maybe speak to the Attorney General to try to see what to do with the stocks and bonds for these companies, or even the assets of the dormant companies, to see whether they can be disposed of, considering the order kept on being renewed?
You know, the order was based on the conclusion of the commission. So basically, you're on standby. That means you cannot do long-term decisions. And if the assets are very valuable and technical, like the gold dust refinery and the container scanner, it was better just to secure it. And also certain assets, you'll have to bring in certain expertise to manage. You know, you're talking about a well-equipped gold dust refinery. So that will also have implications. And some of these companies were in debt, they didn't have the funding to enable that. But we were operating on a short-term basis, so we could not make any long-term decisions. That's why you'll see certain agreements, like the tenants agreements, we just kept it at 12 months. Kept it on a short-term basis, basically.
All right, so apart from these container scanners, the gold dust refinery, what else was found at the airport, at the warehouse that was at the airport? If you need to make references to documents that you've submitted and maybe you have on your laptop, you are free to do that.
Yeah, that's fine. Well, it was 2 warehouses built on the GIPA, built under the Gypsum World Bank project. You know, and it had 2 levels. Upstairs, you'll find offices. It had office furniture, very expensive office furniture. And downstairs, which is more space, that's where you have the equipment. So it was divided. On the right, you'll have Westwood timber equipment. On the left, you have MCG, the gold dust refinery equipment, which was worth about €500,000. Because there was a claim from the Romanians to get the equipment back from MCG. They sent us a claim, and we processed it, but we rejected it. Because we found it not to be valid, because the freeze was also on the Romanians BPI group in terms of being found associated to the former president. So as a result, we cannot process their claims, and it has to go through the High Court. So, but very technical, expensive assets, the objective was to secure it, because we were operating on short-term basis. If you want to put it in operation, you have to bring expertise and also have funding. All these companies were indebted. So, even if you wanted to, there was no funding for it.
All right, so maybe you can pull the mic to the edge of the table, that way. All right,
Okay.
So you stated that these companies were indebted.
Yes.
Was it all the companies, all these 17 companies, all of them were indebted, or was it a few? And can you just inform the committee about what the firm did?
The majority were indebted. Total debt was almost $1 billion for all its companies, 933 million. Half of that was on the litigations at the High Court, because we were facing claims as well. So, to be honest, apart from the hotels, the companies were not standing on solid financial grounds. So, but we have what we call payables. These are short-term debts due within 12 months. Now, for example, if the company is operational and the cash flow can sustain it, we try to bring down the payables in terms of its debts, like utilities, taxes, you know, but long-term liabilities, we couldn't, the companies were not financially strong at that point to cover debts, especially heavy debts. You know, the support they had was from the executive. Now that gone, you know, the numbers as well were going down. So, but we stabilized KGI, stabilized the Abattoir, and based on the cash flow, that's how we managed.
All right, so you've mentioned KGI and the KFF Abattoir. Let's talk about KGI first.
Yes.
So what was KGI's business at the time Augustus Prom was appointed as receiver?
You know, Canalai Farms was the main holding company. So KGI was a subsidiary. So KGI was in rentals. It had 2 properties on Kerava Avenue. It had the bakery. It was overseeing the bakery, but the bakery, I believe it was on the Canalai Farms. But it seems KGI was the main management tool of the group, and we found it, you know, organized, records in place. So it was being managed well by those that were in charge. So, but it was mostly involved in rentals, its main source of income, bakery, and then there was the butcher shop. But I believe, unless I make reference to file, these were under Canalai Farms, but KGI was overseeing it. So that's what I recall.
All right, so the bakery was also being managed by KGI.
Yes.
So, sorry, before we continue to KGI, you had mentioned Observer.
Yes.
Yes. And you said not much was done with regards to Observer. And I think in your statement, let me just maybe refer the committee to the paragraph where the Observer company was mentioned. Yes, paragraph 19. Can you just tell the committee what happened with Observer?
19.
Now you have a copy of your statement, right?
Yeah.
Yeah. Paragraph 19, you talked about Observer. So can you just tell, before we get more into KGI, can you just tell the committee what happened with Observer?
Well, Observer, we took over Observer based on the Second High Court, but we found it indebted to $20 million. It was insolvent. It had a case, had a claim from GRA for 17 million, which was already ongoing. And then, as a result, GRA closed the company via the sheriff. But we didn't have much time to implement procedures like due diligence and all these procedures we have to normally do with a company. I believe we managed it for a few weeks. And then GRA took over because there was already a claim in file. But overall, it was indebted. It didn't have a proper financial management system. There were staff claims. Financially, it was a mess. There was not much that could have been done with Observer at that point, and sales were declining, the cash flow was weak, manual books of records. But by the time we implemented all our procedures, it was closed down by the sheriff. I think AG tried to have it put or release the sheriff's bond on it, but at that point it was too late.
All right, it was too late. So let's go back to KGI and the work that it was doing. You've also mentioned that KGI was able to operate as well throughout the period of the receivership.
Yes.
Were there any challenges with KGI's operations?
Yeah, there were challenges because, you know, at that time, if you take into account the political context of things, you know, KGI had, now that gone, foot traffic went down in terms of sales, debtors were not responding, we even had to engage our lawyer to pursue debtors. So yes, there were challenges. And also staff morale was low because staff had anxiety in terms of what is going to be the outcome, but nobody knew at that point. So there were challenges for all the companies.
All right. Let's go to the abattoir in Abuko.
Okay.
When you visited the abattoir, was there any challenges also? Was the abattoir able to also operate within the 2 years receivership, or did it also have to?
We stabilized the abattoir, but it was difficult to manage. But this is the country's main central abattoir, so you're dealing with all sorts of different groups. Also, the cash flow wasn't that strong, but nevertheless, it was stabilized. Salaries were being paid. You know, the utilities and, you know, what we call the current expenditure was being handled. But financially, you know, it wasn't very strong, and, you know, I believe at some point there was also a limitation in terms of how much it could charge, because you're dealing with different livestock associations. So there were challenges and limitations, but from what I recall, we stabilized it until we handed over. And there was 2 tractors, a vehicle, but those were very old, in bad shape. And also the legal status of the abattoir, it wasn't defined. You know, KGI was a subsidiary, registered, but the abattoir, I don't recall, we did a search, but we couldn't see its legal status in terms of whether it's a branch, a subsidiary, or, you know. So, but it was challenging, but, you know, I think we positioned the receiver manager on the ground, and the management on board were also cooperating, and they, you know, they also did their best. So it was stabilized, safe to say. And we also did a little bit of capital upgrades, we call, you know, in terms of hygiene upgrades. It was about 100,000 or so. But based on the cash flow, you know, at that point, you cannot go and get loans if you're a company in receivership. So we even consulted with Ministry of Agriculture to see if they can upgrade the abattoir based on these agriculture grants. You know, they have funding. I remember they came to the abattoir, the PS Hassan Jallo, we met with them. I met him with the management of the abattoir. So we did our best in terms of sustaining these companies. But there were limitations and challenges, and you also have to take into account the political context of Gambia at that time. So there were many challenges and tricky decisions to make as well.
In all of this, did AP ever update the High Court on the activities of these companies?
Yeah, we submitted 3 volumes of reports to the High Court, and we submitted it to the committee as well, special committee. So yes, we were updating the High Court. Yeah, volume 1, 2, and 3, the final one, and also these copies were given to the AG, former AG, and the Janneh Commission. So because we wanted to ensure we were transparent and not found negligent. So yes, the High Court was well aware. And if you look at these reports, there are also annex sections as well with additional information. It's not just telling you it's 50, there were supporting documents in the volume 1 to 3 reports. So yes, we submitted volumes to the High Court.
So these reports were submitted periodically.
Yes.
Right?
Yes.
Was this because in the High Court orders, if you look at it, it does not mention anywhere that the receiver should, of course, provide information to the court periodically. But let's talk about the first volume that was sent to the High Court, the first volume of the first report, volume 1 of the report.
Yes.
It's, I think, the most bulky. It's the most bulky.
Yes,
it's the most bulky report that was sent to the High Court.
Yeah,
You've mentioned before we get into the content of the report. You mentioned that you also did submit a copy of this same report to the Attorney General and even to the Commission.
Yes.
So to the Commission, was this a request, or did just AP decide on its own that since the Commission is also investigating these assets, should we provide a copy to update on the status?
I can't recall a request from the Commission for the reports, but because of its mandate, we thought it important that they have a copy. And at some point, they did write, there was one correspondence asking about the Japanese rice, which were the Japanese rice grant. But that was not connected to the receivership because we audited the Japanese grant. There was a letter from the lead counsel, from the Commission. So we gave information on the Japanese grant. But in terms of a letter requesting receivership reports, I don't recall it. But nevertheless, AG and the Commission had a copy of all the reports.
All right, very well. Let's take a look at the first volume 1 of the receivership report.
Yes.
Do you have a copy?
Is it the executive summary?
No, the entire report.
Yeah, you can go ahead.
We can give you a copy
Yeah, I think it would be easier because
Yes.
there's too many files.
All right.
Thank you. All right, thanks.
Honorable Chair, is the committee at volume 1? All right. So, Mr. Form, can you just take through? It's a bulky document. We're not going to go through. We'd spend the entire day here, so we're not really going to go through this report page by page.
Okay.
But can you just take the committee through the report and just, guide the committee on what what the firm was reporting on or updating the High Court on?
Well, like you said, it's bulky, but this is more of a due diligence report based on our initial findings of these companies. So it's just giving an overview of all these companies on the High Court orders in terms of their legal status and in terms of their financial status. So it was basically, that was the objective of volume 1, because this was the first, I believe the first, May to September period, the initial period. So this was like the due diligence period for which we were giving the High Court an overview of the information we found in terms of legal, assets, and financial status. And most were, as stated, were dormant, apart from KG and the Abattoir and Observer, which was shortly closed after we took over. But it has a lot of information, so unless you want to get to a particular point, I think otherwise we might be here for a long time.
Let's go into KGI.
Okay.
Yes. KGI and Kanilai Wani Family Farms Limited. So KFF, KGI and KFF. Sorry. So you've talked about the debt these companies have, right?
Yes.
So on page 6, there's mention of claims. The receivership has received claims for which are currently under review and in litigation from quite a number of institutions and banks. Let's go through page 6 to page 8.
Okay.
And we go through all these claims that these companies were being faced with.
Yes.
And we can start with NAWEC. So what was NAWEC's claim, and also what did the receiver do?
Well,
when it came to NAWEC?
NAWEC's claim was 53 million against KG and Kanilai farms for unpaid bills. It was, but luckily, NAWEC never took us to litigation, but they were writing to us. But because of the company's financial status, these debts couldn't be settled. So what we did when we took over, the current bills, that's what we paid moving forward, in terms of what the companies could afford. But, there were too many claims. At some point, we even met the AG and gave him concerns about his claims, but he wasn't too helpful because he was making a lot of fuss about fees, legal fees, your lawyer, this, that. So we told him, okay, how about we use I think you have the National National Legal Agency.
National Agency for Legal Aid.
Please remember, you're a lawyer. So, but we were concerned because all of a sudden there were claims coming in, and the claims have to go through the receiver. So we were in the front line. So we brought it to AG's attention, but he wasn't very helpful about it. So we had a lawyer, Bandera Associates. They did a good job. His fee was reasonable, and they made fuss about the fees. He had to give a discount of $2 million. So it was basically a pipeline of claims coming in. You know, the former president is not here, so now everybody is brave. Go and see Prom. You know, tell Prom to pay you, tell Prom to, you know, do this, give you this. So it was, anyway, we defended what we could. But most of these claims were not settled because of the company's status. And claims that came through the High Court, we defended with a lawyer. So, but now when we took over, future bills moving forward, we paid. But as far as previous bills, I remember they always used to write on call, but we told them, well, you know, looking at the status and legal situation, we cannot settle this. But they never took us to court as a receiver.
All right. So all of these claims listed in these 2 pages,
yes,
or I'd say 3 pages, they all came about after the receiver, after AP was appointed as a receiver. So you did not meet any of these claims when you just first took control and custody of these companies?
No. Yeah, I mean, the companies had their liabilities.
Okay.
Whether it was disclosed, recorded, but I know these claims came after the receivership.
All right.
You know, so.
So NAWEC was owed $53 million.
Yes.
And you only decided to pay the bills that came in during your time, and the bills that happened before your time.
If the cash flow could have settled it, we would have settled it. Because you'll see other companies that had cash flow, we brought down payables by 90%. So it based on every month the cash flow coming in, and based on that, first you pay salaries, taxes, utilities, and then after you worry about debt. And also we're operating on a short timeline, 6 months. So, you know, there was not much we could do. But if there was funding to settle it, and what we call the Companies Act requires the receiver to make commercially reasonable decisions, we would have done it.
Okay.
But as a receiver, it's like the company is your responsibility. The director's powers are frozen. So you're in charge, you're in the firing line.
All right. Yeah. Up to the point you were handing over KGI International and KFF, did this figure owed to NAWEC ever reduce, or did it just stay at the 53 million?
I'll have to make, but I don't think we settled the NAWEC liabilities. I can't recall. But I do know that based on the bills that came in when we took over, we were settling that based on cash flow. But whether it went down, I'll have to make reference to our record.
All right. I believe volume 3 is what you submitted at the end of the receivership, isn't it?
Yeah, volume 3 is A and B.
A and B.
Yeah.
When we get to volume 3, all right. So Social Security.
Yes.
Social Security also had claims.
Yes.
Here it states that Social Security was claiming for $10 million and also interest of $2.7 million, $795 million as well.
Yes.
Was this how, again, you said that this claim was, actually, there were 2 different claims from Social Security, it seems.
Yes.
According to the report. Let's talk about the first claim. So the first claim also came in after AP was appointed as a receiver. How did you receive notification of the claim? Just take us through that.
I think they call it what you were served, right, in legal terms.
Yes, so you were served.
Yeah,
but what were you served with?
Basically, I think it was like an ex parte motion that, you know, as receiver, you will have receiver as defendant, you'll have KJ as defendant. I think even there were some AG was defendant, if I can make reference. But we were the first, I think, defendant as receiver. So, but what was funny was sometimes, you know, if you're served, you have to respond within, I think, 10 or 14 days. I don't remember exactly. So, but sometimes we'll get these summons or these notices just a few days before the deadline. So I remember there was one weekend we had to sit with a lawyer to draft affidavits, go over the motion to defense. so that by Monday or Tuesday, our defense will go into the High Court. Otherwise, we would have been found negligent. So, but it ended up at the High Court. So it was under litigation. But at the time we were handing over, most of these litigations were not, were still ongoing. So, so when we handed over in June 2019, the litigations continued with the lawyer. But I do remember certain cases we had to act fast. Otherwise, we will lose the properties. Talking about, you know, over almost $2 billion in properties if you just combine everything together. So otherwise, you'll be found what they call negligent as a receiver. And I remember there were certain claims that put us on the what we call the undefended list or something like that, which means the court should not even bother. Like, you know, there's no case to answer here. So it was very legally technical. But we had a lawyer from Bandera, and he did a good job, Mr. Ba. So we were dealing with litigations at the High Court. I think there were 4 to 5 or so, 2 from Social Security.
All right, so eventually, was this claim still outstanding at the end of the receivership by June 2017?
Yes.
So 2019?
When we were concluding, the litigations were ongoing.
Were still ongoing, so therefore this sum was also outstanding.
I believe some of them are still ongoing from what because there were times they would write to us, we would write back to the lawyers telling them we are no longer receiver, right? Take it to the new receiver.
Okay.
Yeah.
All right. So let's go to the second Social Security claim. Let's take a look at the second claim. Sorry, before we go to the second, we've been talking about the sum for the first claim, but can you tell us exactly what the claim was? This a loan that Social Security, well, of course it's a loan, but how did, I believe it is, which of the KGI, so how did KGI come about obtaining this loan from Social Security?
Well, I know one of them, you know, these companies had executive support. So one of them was for purchase of rams for Tobaski. And the other one was for water tank, imported or something to that nature, from what I recall. But basically, these companies owed Social Security and it was not paid.
All right. And do you know the date in which Social Security provided these loans to KGI and KFF?
I'll have to make reference to file.
All right, so that will be part of your submissions on Friday.
Yes, if we trace it, we'll send it to you. But I believe it should be in file, yes.
All right, so the second Social Security claim, that's for KFF. It states that KFF owed Social Security $6.432 million and interest of $3.95 million.
Yes.
Was this claim, was it also before the courts? Was AP notified through a motion at the High Court?
Yes, I believe this one was at the court as well.
All right, and these motions that you were receiving, who was filing these motions on behalf of Social Security?
You mean the law firm, the lawyers? And the Bensouda and Co. legal firm.
All right, and these motions, were they filed right after AP was appointed? Because the first appointment, especially for KGI and KFF, was the 22nd of May.
Yes.
Yes, so were these right after you received this motion and the notification of 1st June 2017, was it, or was this subsequent? Did it take a few months before you received notification?
To be honest, I'll have to make reference to file, but it wasn't long before we started to receive claims. I don't remember which particular month, but I do recall it wasn't long before we had a pipeline of claims coming in, you know. So it was once it was advertised in the newspaper, there's a receiver, High Court order. So now there's a point of contact to get your property or asset. So we were receiving claims, and the exact month I can make reference to file and send you the information, but I don't remember, but it was not long before we started to get court claims and litigations and whatnot.
Honorable Chair, there are documents that the committee has received from the High Court of the Gambia, and in particular, on this topic we're right on, there's a document, and the witness is saying he needs to look into his file to give us a date. So I have a copy. It's just one copy that the High Court has, that I have with me right here. So if Secretariat can pass it around to the committee to take a look and then after give it to the witness.
All right, thank you.
Let me help you out, Mr. Prom.
Yes, yes.
You can stick to, I think, the first 2 pages. The
Okay.
others are attachments.
Yes, that'll be done.
A copy of the order of the 22nd and other things.
Yes, yes, yes.
Yeah, and the annexures.
Okay.
That's why the document looks bulky,
Yes.
but the motion is 2 pages, I believe,
Okay.
if I'm not wrong. So if you need time to look.
No, what do you want me to clarify on?
Yes, you were mentioning dates, so I asked you when.
Yes, it's,
So can you just read out the date to the committee?
it's dated 15th day of June 2017.
All right. Can you turn to the first page, or are you already on the first
Yeah,
page?
I'm on the first page.
Okay. So at the top it has the parties.
Yes.
All right, and then I believe after the parties there, just before the prayers.
Yes.
Yes, if you can just read out the parties for the committee.
Yes, the High Court of the Gambia civil suit between Attorney General and Alhaji Yahya AJJ Janneh in the matter of an application by Social Security and Housing Finance Corporation, a creditor of KGI Company Limited, a company on a restraint order of this court dated 22nd May 2017, and in the matter of application for leave to bring an action against Augustus Prom, receiver of KGI Company Limited, motion dated 15th June 2017, for claiming for debt of 10 million with interest 12.795 million.
All right, that's the first claim.
Yes.
That's the first claim that we just talked about. And then subsequently, at a later date, you also received a motion again for the second claim.
Yes.
Is it?
I believe it should have been around that timeline. I can't recall exact dates unless I make reference to the legal file, but
No, actually, not the date, but we have a copy of that motion.
okay.
Yes, but to say that, to identify that these claims are separate.
Yes. Yeah, you have one
Alright.
against KGI, one
And then the
against
other one,
Canalite
and they
Farms.
did not come in together.
No, yeah, it was separate litigations, yes.
All right. Both filed by Ame Bensouda and co-legal firm.
Yes.
All right. Did your legal representative respond to these motions
Yes.
and filed copies?
He'll come to the office.
Filed, yeah.
We will sit down, draft the affidavit, go over the motions, give our feedback, and then he will file. Otherwise, we would have lost these properties.
All right.
Yeah. So yes, we had a solid legal defense.
All right. So let's go back to the report. Page 7, the third claim.
Yeah.
Sorry, the fourth claim. Yes, the fourth claim.
Do we still need this social security motion, or I can?
Yeah,
give it
you
back?
can. Secretariat can please take that. Hannah B. Silla of Future Like Gambia Limited.
Yes.
As well. Was this? Did you also receive notification of this claim through the High Court? Motions filed, or also?
Yeah, I recall it was a High Court litigation filed by the same law firm for the Future Act property on Kotu. But we put in a defense, and I think they lost the case. From what I recall, I think this case was lost by the Hanabi Silla. I think they're businessmen from Conakry. I think they own the property. They lost it to GT Bank. The former president bought it, I think 52 million. And then with the new political context, they came back and tried to claim it from the receiver after they already lost the case. So you understand? So I think the matter ended up at the Court of Appeal or something, but I do know that this party, Hanabi Silla, lost the case with GT Bank and lost the case with the receiver. But I have to make reference to the legal file. It was very bulky.
All right. So property was attached after a suit with GT Bank, and then it was bought by the president.
Yeah, they had a mortgage GT
Very
Bank,
well.
they lost it, former president bought it, and they came back and fired at the receiver.
Okay. All right. And they claimed for 100 million.
Yeah, the estimated value of the property. But I
Alright.
think by now it should be worth much more.
More than that.
Yeah.
Very well. Let's go to GRA. KFF's debt to GRA as well. So this KFF owed GRA 75.477 million,
Yes.
and this was unpaid corporate income taxes.
Yes.
All right. So did the receiver also receive information about this claim from GRA directly, or is it that it was already there from the books of the company? You can find that this amount was outstanding and owed to GRA.
I think it came after.
It came after, and
think,
GRA
yeah.
notified.
GRA wrote to us on these claims. At some point we had a meeting with them, and we gave them a briefing on the situation, the company's cash flow status, that looking at the current situation, these companies are frozen, there is no access to cash flow to pay 75 million. So, but I remember GRA wrote to us, we had a meeting with them, and but they also knew the situation of these companies. These companies were, apart from KGI, I don't think these companies were paying tax. The Abattoir, we paid POIE tax, but because its legal status was not defined, it was not like a registered company like KGI. From what I recall, I don't think corporate tax was paid for the Abattoir. But we were trying to see if we could get a tin for the Abattoir. It was in progress, from what I recall, so that we could pay taxes for the Abattoir. But there was restriction in terms of its legal entity status. It seemed to be just a offshoot or branch of KFF without any proper legal structure. So, but yeah, I think this claim from GRA came after, but I'll have to make reference on the exact date, because there were, thousands of documents we were dealing with, so.
Did KFF pay like the Narek situation where the debt before the receiver was appointed was set aside, and then the subsequent amounts owed were being paid? Was that the same situation here? Was the same situation adopted here?
For Canalai Farms?
Yes, or was corporate tax just not paid at all during the 2 years that?
No, KGI tax was paid.
Okay.
But not, it was Canalai Farm, it was the main holding company, but it had no structure. I remember there was a proposal in file. The former president had plans to do some restructuring, consultancy. It was at the tendering stage. I think Canalai Farm was going to be restructured and make it more, I guess, more viable and more organized. But I guess this couldn't be completed.
Oh.
Yeah.
Okay. And towards that time, the receivership ended. In 2019, this amount was still outstanding.
Yes, from what I recall, yes.
All right.
Because there was no funding to
Funding set it off.
Yeah, if there was, we would have settled it.
Okay.
But there was no funding or no bank loan access.
All right. And the next one is KMC.
Yes.
So KMC was owed 520,000 from the Central Abattoir in Abuko
Yes.
for unpaid trade licenses from 2008. So KMC did not claim these amounts from 2008. So when you also took control and custody of the abattoir, did you learn about this outstanding sum from the books or also from a claim sent by KMC?
I believe there was a claim from KMC.
Okay.
Yes.
All right. Was this outstanding sum ever settled?
We were paying licenses. Now, whether this sum was settled, I cannot recall. I'll have to make reference. But I know
Paid for subsequent licenses.
I believe, yes, we were paying KMC because they were putting a lot of pressure on the abattoir. So based on the cash flow, we paid what we could.
Okay.
Yeah.
So like this, basically the same situation with NAREC was adopted here.
Well,
The same strategy?
To be honest, I cannot confirm, but I do know if the companies had cash flow, we settled debts. Now, whether this was cleared, it's possible it could have been cleared, but I'll have to, make reference and get back to you on that. But I do know during our time, whatever was brought in and there was cash flow, we settled it because we didn't want any payables building up during the receivership period.
And AMRC,
Yes.
their claims, it did not go to, you did not receive notice of it through litigation. You received claim of it maybe via a letter or a visit?
I believe there were letters claiming.
Okay.
Yes.
So what happened with AMRC? What was the situation? Were you able to settle it, come to an understanding?
I believe that there were no records in file to show that the warehouse was owned by KGI or KFF, and AMRC provided proof of ownership. So at some point, AMRC, I believe, took custody of their warehouse.
All right. Is this because KFF could not prove ownership and?
Yeah, we also wrote to the Registrar General for leases for all these properties, but we couldn't get access to the leases. Okay. Because you need the lease to show who owns it. So, and the proof of ownership came from AMRC, a government entity, and it was valid. So I believe in the end, the warehouse went back to AMRC.
Was this discussed, this issue, was it discussed with the AG?
Yes, yes.
All right.
All these, AG is a party to the case.
Yes.
So what we call
this one is saying it did not go through litigation.
No.
A direct claim to the receivership and did not go through litigation. So how was the AG informed about AMRC proving ownership of?
Well, probably through correspondences.
Okay.
Yes.
All right. And the AG was aware?
Yeah, because when these claims started coming in, we brought it to AG's attention that there's concern. There are too many claims coming in. It will cost a lot of money to hire lawyers, but he wasn't of much help. I don't think he cared much about it. So we took our own initiative to hire a lawyer, and then he came back and made fuss about the fees, unfortunately. But he's a party to the case, so you have to, what we call in a receivership, give them an ear. Because normally you have shareholders or creditors contending over the assets, but in this case you have the AG and former president. So whoever is there, you have to give them what we call an ear, hear their concerns, and then you make the best decision. So, but I do remember, there were meetings and correspondences on these legal claims, and we shared our concerns, but we could not get much support.
All right, we can go to FI Bank on page 8.
Yes.
FI Bank also claimed for 12.708 million. And this one, you received notification of it through litigation.
Yeah, I think they had a joint venture with KGI, then the bank came back to claim. I think KGI provided, 4 properties as collateral, located at Sukuta, that were already sold by the bank to Global Properties for 10 million based on a court judgment. I don't recall it going to litigation, but there was a claim from FI Bank, but I don't think it was standing on strong grounds at that point.
All right, so the 4 properties that were used as collateral were eventually sold by the bank.
Yes, by, I believe, a court judgment to claim back from KGI.
Okay. The AG was also made aware of this.
Yes, he was.
All of this.
All the claims, he was fully aware.
So this report, before we go any further into the 2 remaining
Volumes.
the 2, no, not the volumes, the 2 remaining claims.
Yes.
When this was filed at the High Court, what was the court's reaction to this submission?
Regarding the claims?
Yes, regarding the claims.
Well, I don't recall any reaction from the court because all these claims were independent litigation. So
All right.
I don't recall any reaction from the High Court on these claims.
So, did EP ever think about, I know this was not done, but maybe, did AP ever think about going to the court and making requests, at least for some of these suits, but these claims that came through litigation, in any way, or even the ones that did not come through litigation, all of these claims, did AP at any point inform the court of maybe for the court to grant orders to sort of stall these claims?
We did. We wrote to the Judiciary, yes. We actually wrote to the Chief Justice as well.
Okay.
But the response was they could not engage the matter because each claim was independent litigation.
Okay.
But we did bring the matter to the Chief Justice. He was sympathetic, but I guess they couldn't do much. But former AG was not happy about that, from what I recall. The fact that we took it to the Chief Justice, because he was not helping, and we didn't want to spend millions on lawyers, so we brought it to the Chief Justice's attention that you have a case, High Court case, where assets are frozen, and there are parties coming through the High Court to claim those same assets. It's like well, I will not say conflict of interest, but some sort of a duplication of the judicial process. But we did bring it to the Judiciary's attention. Because we first brought it to the AG's attention, we could not get much help. Then we took it to the Chief Justice. He was sympathetic, but he said he couldn't do much. But I do recall the former AG was not happy that we took it to the Chief Justice, and he told us, you should have come to me. But we already did that. You didn't respond. So what do you want us to do? Just fold our hands and people come and claim billions behind the back door? We didn't do that. So we took up our own defense. And then they made so much fuss, AG and the former commission, about our lawyers' fees, which was very reasonable. If you ask me, too low, knowing what lawyers can charge for high-profile cases. So.
All right, so the commission was also aware that AP had decided to engage the Chief Justice about this issue, all these claims.
I'm not sure if the commission was aware, but AG was aware that we took it to the Chief Justice. And probably AG was in close contact with the commission, so most likely they knew. And we also had cases of the commission that we'll get to at some point, that we have to defend. So most likely they knew, because there was a close link between, it seems, between the commission and the former AG.
At what point did AP decide to engage the Chief Justice with regards to all these claims? Was it during the first 6 months Or the first order, was it after the renewal?
To be honest, I can't recall the date, but there's a correspondence in file. I can send it to you.
Oh.
Yeah, but I remember there was a correspondence. He responded, we have that, we can send it to you. But with exact date, I'm not sure. But we did bring it to the judiciary's attention that, you know, there is this pipeline of claims coming in, and it doesn't make sense.
All right, so let's go to the second to last claim.
Yes.
GRA, and the claim is with regards to Westwood, claiming 2 years of unpaid income tax.
Yes.
Estimated at $156 million. So this, like the other claim that GRA had, it also did not go through litigation.
No, GRA wrote to us, but they didn't, I believe they were more reasonable than the other parties, knowing the legal situation, and it's a state matter. So, but they wrote to us, and we had a meeting with them, and we told them, gave them the status of these companies. And it was, their financial status was indebted. There was no money to pay taxes unless you liquidate assets, and that was not our objective. So, and Westwood made about $40 million, so I think GRA had a strong ground to claim taxes, because they were, I don't recall them paying taxes.
All right, and this was not paid during the 2 years, was it?
For Westwood? Mm-hmm. No, because we found it dormant, there was no funding, it was indebted, so no, we couldn't pay.
All right, let's take a look at the last claim, again from GRA, sorry, from Social Security. And this one is interesting, no litigation. So it's claiming $1.646 million from Observer Company Limited for unpaid staff contributions.
Yes.
How did AP address this, considering you had told us earlier that within a month of the receivership, the sheriff had closed down Observer and basically taken control. So this was outside.
Yeah, you know.
Yes, Observers listed by the court, but
yes,
still outside the control of AP. So how was this handled, this particular claim?
You know, Observer had different debts, 20 million total, 17 to GRA. That's what we found there. So I guess Social Security, because you know, when it comes to insolvency, the tax authority has priority. I think in terms of priority, the tax authority is number one, then you take care of staff, and then you have different categories of creditor, floating charge, fixed charge. So, but tax authority has to be given priority in terms of debt repayment for these companies. But I think Social Security knew that GRA had already shut down, taken control of the Observer. There was nothing to claim because the first party has already taken charge of the company. Well, there's nothing left. So I think that's why, from what I recall, I think that's where it stopped. But there were also staff litigations at Observer. You know, Observer was not properly managed. There were so many issues.
So there were also staff litigation that were ongoing before AP was appointed as receiver?
Yes, I believe so. And at some point, some staff, I think, took AP to, there was one case, they took us to the Carnegie Tribunal. But in the end, I don't think it was settled because there was no assets for the receiver to pay you. So I think the case was thrown out. I think one Maurice Gomez or something like that.
Okay.
Yeah.
All right. So we've now discussed the claims that AP received at the beginning of its receivership, and this report spans from the day the order was delivered by the High Court, 22nd May 2017 to 30th September 2017.
Yes.
All right. Honorable Chair, I believe this is a convenient point to take a break before we get into other issues.
Yep, thank you, Council. We can take a short break for about, it's almost 2 o'clock. Can we come back around 2:30? 45 minutes? Or 3 o'clock?
I think we can.
3 o'clock?
Yes, please.
Meeting adjourned until 3 o'clock. We can resume, yeah. 3 o'clock. Mr. Prom?